Welcome to our 5th episode of In the Trenches with Inventors, brought to you by US Inventor. Each week, we'll be hearing real-life stories from inventors about how and why their patents were invalidated. I'm Natasha Ruckle, your moderator. Our webcast today will last 60 minutes, and we have yet another interesting line of panelists for you to listen to. Our guests will tell you their stories and then participate in our debate topic, What has US Inventor accomplished over the years? We highly encourage you to use the chat feature located at the bottom of your Zoom window so that you may have a live dialogue throughout with our panelists. And if we get time, we'll try and answer some of your questions at the end. Don't hesitate to post your questions in the Q&A button, also located at the bottom of your Zoom window. I'd like to introduce your host for today. He is the president of the US Inventor organization. He's an inventor with 3 patents. He's a former president and current board member of the Tampa Bay Inventors Council and president of Complete Product Development, a firm that does CAD design, prototyping, and short runs. At US Inventor, Randy works with inventors across America, enabling a grassroots effort to restore the rights of inventors in America. So, Randy Landreneau, welcome. What is the role of US Inventor and what is today's goal?
So just to give you a little background, US Inventor was formed in the middle of a big fight to stop a terrible piece of legislation from being passed. Now, a terrible piece of legislation had already been passed a few years earlier, the American Invents Act, which we'll talk about during the show. But even just 2 years later, another terrible piece of legislation that was perhaps even worse was about to pass, and I started fighting it, and another inventor, I found him doing the same thing as I, Paul Morinville, and we went to Washington, D.C., and we fought that thing door to door in the Senate. And our effort, and it became a huge fight with even the next Congress as well, but our efforts, the efforts of us as US Inventor, connected to inventors all over the country, made a big difference. We were instrumental in stopping that bill. And I got to tell you, from my standpoint, when I first found out that large corporations were working all the time with their attorneys and their lobbyists and their mountains of money to make it harder and harder for an inventor with a significant patented invention to be able to stop them from just taking what he or she had invented and patented, I was outraged at that. And they have been working overtime on this for a very long time, and many years actually. But in recent years, they've gotten very good at pushing these bills through. And of course, US Inventor stepped in and became our voice because we didn't have a voice before. We had very little voice, amazingly. But you know, we're inventors. We're not lobbyists. We're people working on projects. A lot of us aren't very political, and we didn't have a voice. And we're lucky we had any rights left, to tell you the truth. But now US Inventor is on the job, and we're there. And the big effort right now, though, is to restore the rights that we've lost. And that's what our entire total dedication is to. You should be able to invent something hugely important and valuable that you can stop even the most powerful corporations in the world who want to just take it from you. As an inventor with a patent, you should be able to stop them, even if you have no money, okay? I mean, let's say a little bit of money. Yeah, you gotta have a few dollars in your pocket, but you shouldn't have to be rich to stop them, because this is a right that is in our Constitution, has been with this country from the very start. It's why America has led the world in innovation for 200 years, and it's what we've lost in recent years. So we have inventors on today's show who will talk about what they have been through with our currently broken patent system. And it'll be eye-opening for you, and you will see why it's so important that we restore the rights of inventors.
Well, thank you, Randy. Now, I see behind you have a big sign that says 84% of patents are invalidated by the PTAB.
PTAB.
What's the PTAB?
The PTAB is the Patent Trial and Appeals Board, okay? It was created by the American Invents Act, which passed in 2011. It was sold to Congress by these armies of lobbyists from multinational corporations. It was sold as a cheaper, faster, a more efficient but fair alternative to district court for patent litigation, especially for invalidating patents that they claimed shouldn't have been issued. That's how it was sold. what it really turned into was the tool of choice by a large infringer to invalidate your patent. 84% of the patents that go all the way through the process get invalidated, 84%. And an awful lot of patents don't go through the process because the inventor gives up because they can't afford to fight it. The cost is typically very high for a decent defense. The AIPLA says, that's the patent lawyers trade group. They say it costs between $400,000 and $800,000 to mount a decent defense of a PTAB attack. You typically can't, it's very rare that you can do it on contingency. Historically in America, you would fight these cases on contingency because you don't have money, but you can share the winnings with the attorney if they win it. And of course, it had to be a good case. It wasn't perfect, but you know what? It was a way to get to court. Now, though, with the PTAB, the chances of getting contingency are close to zero. You just have to have the money in the bank. And you know what? If you win one, they can do it to you again and again. You can face multiple PTAB attacks. Some of the individuals who are on this webcast have done so. In fact, Josh has faced numerous PTAB attacks. And it's totally unfair. It wipes out the little guy. It destroys what our patent system was supposed to create, which was the incentive to invent because you could own what you created. So in fact, every person on today's webcast has been through a PTAB attack, at least one, and they'll tell you about it in the webcast.
And that brings us to our first guest. So many toxic gases and other pollutants like greenhouse gases can't be seen by the naked eye. So how do you determine if they're being emitted? There's been a technology in use to detect gas leaks called sniffers, but this requires excessive time and manpower and provides limited results. Well, our next guest, David Furry, invented and patented the solution optical gas imaging that actually allows the user to see the gas leak. And we're going to look at a little video here. Now, as you watch the smoke in this video, it's important to note that you wouldn't see this with the naked eye. David's optical gas imaging allows us, or indeed anyone using this device, to detect leaks such as the ones that you're seeing in this video. Now, the use of David's invention lowered the level of ethylene in the air in Houston by actually 60%. Ethylene is a VOC, a volatile organic compound that actually causes cancer. Now, David was working with a large corporation that appeared to be interested in licensing his invention. They ended up learning everything they could, and then they just took the technology. David, thank you for joining us. Can you tell us what happened when you tried to stop these people?
Thank you for letting me tell my story today, and I really appreciate all the things that you guys do. But the short version of my story is that I never dreamed that it would not be mine. The PTAB, with their broadest interpretation of prior art, compared and changed my definition of a leak, and basically said that a leak, a jet engine exhaust is a gas leak is the same as a pinhole leak in a water hose, and that's how they brought this prior art in. We were a lot more. I'm sorry, I'm a little nervous, but our claims were a lot more narrow than that. But the PTAB expanded them out. I just never dreamed that when I built this thing back in 2003 that we would be where we are today, because I put the money up to build it. I showed it out to the industry. I promoted it. I did everything I could do to make this a industry standard, which it is today. It's an industry standard. There's actually EPA rules that allow you to use this equipment for leak detection. But I just never dreamed that PTAB would take it away. I never dreamed that in my wildest dreams. I did all the work. I did everything in the beginning, and got it to that point. And then the company that took it away took it and marketed it. And they actually, did it while my patents were pending, of course. And then I was expecting the patents to be issued and start collecting royalties, and that never did happen.
So, David, in your case, the company that ended up just taking it, you were working with them. They were working with you. You were showing them how the system worked, and they were apparently, I mean, as far as you knew, they were looking at licensing the invention, right?
That's what I had thought. Like I say, I actually furnished them the first filter that for the first camera, and we did work together in the beginning because my patents were still being going through the process. And by the way, Randy, my patents, I don't know if I've told you this or not before, but they actually went through the appeals process, and I was issued a patent through the appeals process, and then killed in the PTAB later on. So this was a very extensive patent search, and they ridiculed my patents for 10 years before we got to the appeals court. I mean to PTAB, and like I say, I just never dreamed. I never dreamed in my lifetime that a patent that you worked so hard. I was always told that if they really, really ridiculed your patent, that your patent was really bulletproof, but that's not the case in the PTAB.
Yeah, and we've seen many cases where basically they bring in prior art, that doesn't apply to your patent, right? Or in some cases, they use the same prior art that your examiner looked at, and they say, well, we just think it's obvious because we have a different opinion than these experts at the patent office, which is another issue. Typically, the PTAB quote judges, they're really just administrators. They're attorneys, basically, employees of the patent office. They typically don't have anywhere near the experience of the patent examiners, who are the experts who actually granted the patent. Was that your experience as well?
Oh, definitely it was. They brought in some of the prior art that the examiner and the appeals court had, I guess, I don't know the right word for it, but approved or looked over, and brought it back into play. One of the things that we tried to stress so much on the prior art is, yeah, there's some old prior art out there, but it didn't work. If it would have worked, I wouldn't have ever built the first camera. I would have bought one, but it didn't work. And we just never really ever convinced them that equipment wouldn't do what we're wanting to do. Now we have narrowed the claims more. We have a provisional patent that's still out there that we're still working on, trying to get it narrowed, but our time's running out. I have 6 more years. That's all I have left. So we're pushing real hard to keep going. But
and this is just for the viewers. Think about it. What David invented, it has actually lowered the level of ethylene in Houston by 60%, because now they can see the leaks. They can see the leaks, and they can actually find out where they are, and they can stop them. And it's hugely valuable. And this is the kind of thing that inventors need to have an incentive to invent. And when it can just be ripped away from you by a big corporation with a lot of money, with a broken system that they can game like crazy, it just throws into the trash can what this country was built on. So I tell you what, David, we all feel for you, and we're working day and night to try to fix this system. So hopefully, if you do get that other patent that you've applied for, maybe you'll have something you can use.
Well, thank you, and I do appreciate everything you guys have done, and I know I've talked to Josh many times, and I know y'all do a lot of good work there. Unfortunately, I hadn't been able to join you because I'm still busy and trying to work on this stuff, but we do appreciate everything you do. All the inventors do.
Thank you. And I think I'd like to introduce Josh Malone at this point. For those of you who are joining us for the first time, let me introduce you to Josh. He's our resident expert. Now, he quit his corporate job in 2006 to take his shot at the inventor's dream. 8 years later, savings depleted and kids' college unfunded, he took one last swing before drudging back to the corporate world. And he hit the home run with a bunch of balloons. His solution to the 63-year-old problem of filling and sealing water balloons instantly became the #1 selling summer toy. Now, his invention was stolen by a notorious serial infringer who convinced the USPTO to revoke his patent under a controversial procedure of the 2011 American Invents Act. A brutal and costly legal battle combined with an anti-corruption crusade ultimately resulted in a $31 million award and restoration of his patent rights. Well, Josh spends a lot of time as a full-time, actually, volunteer with US Inventor, and he's working always behind the scenes really hard. So thank you for joining us, Josh. Now, I want to introduce you to our next panelist today. Patrick Buckley has 9 patents on inventions in many different areas. And actually, some of what he's done even got publicity from a former president. Let's have a look at this video.
Another example that's near and dear to my heart because I actually own one. It's a Dodo case. Somebody have my Dodo case around here? Let's bring out my Dodo case.
Today, we're going to talk about the first invention of the first low-cost smartphone virtual reality viewer that works with all smartphones. Now, this foldable cardboard device that you connect your smartphone to for virtual reality. Now, in creating this invention, Patrick solved problems that others at places like Google had been unable to solve. He licensed it to a particular company and sales were rising rapidly. But then they changed their mind and decided to use the PTAB against them. Patrick, thank you for joining us. Can you tell us what happened?
Hi, thanks for having me. Yeah, so in our situation, what happened was we developed this low-cost input mechanism for smartphone virtual reality. We were in the marketplace selling a product, waiting for our patent to issue that would protect the product that we were manufacturing and selling to people. Right before our patent issued, we had the company that owned the Sharper Image brand approach us and proactively asked to license the patent for a product that they were preparing to enter the market for the holiday season. Our attorneys were really surprised that they were proactive in coming to us and asking for a license, which is very rare these days, I guess. And we negotiated a deal. We got, a license in place. And then unfortunately, what happened was about a year after that license was in effect, they decided after being acquired by a big private equity firm that they didn't really want to abide by their agreement. And they started complaining and threatening not to pay. And even though we had a contract and a licensing agreement, we quickly learned that basically, I was worth about as much as the paper that it was written on in the current system that we have. And we tried to enforce our contractual rights, went to court, which in our contract said that was the venue where disputes would be resolved. And they quickly ran to the PTAB and basically threatened us and said, we will file these PTAB proceedings against your patents unless you take pennies on the dollar of what this contract says you're owed. And we looked, they sent us their filings 24 hours before they were going to file them and said, this is what we're filing or else. And we looked at them and we thought, this is just complete garbage. I mean, they had prior art in these, PTAB invalidity challenges that came out 6-7 months after we had already been selling the product. After we'd been in the marketplace, I'd spoken at a number of conferences, we'd sold tens of thousands of product, and they were using prior art that came out 6 months after that. So we thought there was no chance that they were going to be able to use this alleged prior art to harm our patents. Unfortunately, the way that the PTAB works is basically it gave them every benefit of the doubt. And we were forced through going into the PTAB and also fighting in the district court, which was incredibly expensive for a small company like ours. This company, MerchSource, was backed by a private equity firm called AEA Investments that had $15 billion under management. And what had happened was when they had come to us to get the license, it was just MerchSource and the Sharper Image were, hadn't taken investment from this private equity firm. What had changed between when they were proactive about coming to us and licensing it, and when all of a sudden they decided that they could just use the legal tools at their disposal to completely, grind us down in a war of attrition, was that they got, funded by this private equity firm. So, clearly they had the playbook for how to use the patent system to their advantage against a small entity like ours. And that's basically what happened. We did have some successes in our legal case. Early on, we asked the district court to have MerchSource withdraw their PTAB petitions because of the venue clause of our contract. And the district court agreed with us and told MerchSource to withdraw from the PTAB, which would have kept us in court like our contract stated. However, because they had so many resources, they said, well, we're just going to appeal that decision. And then it went to the federal circuit, and the federal circuit said, we're staying the lower court's decision, putting it on hold, and then proceeded to take 1.5 years to hear the appeal. In that time, the PTAB basically instituted. We thought the PTAB wouldn't even institute these challenges because it was so bad, but we were wrong. They instituted those challenges, and now we were facing, a $400,000, $500,000 legal fight in the PTAB, which we didn't have the money for. And so we had to find a partner, and I literally had to pay someone to take my patents, basically give them an expense fund, and they would do the legal work, kind of on contingency. But in order to keep the PTAB proceedings alive and be able to fight them, we had to give up our patents. Federal Circuit eventually heard our case, agreed with us, told MerchSource that they needed to withdraw from the PTAB. But by this time, we were within a week of the final PTAB written decision. And so all of the expenses had been expended at the PTAB, and we had already lost our patents, and all of the damage had basically been done to us. So even though we had a contract, even though that contract said we should be in the courts, we still were dragged through the PTAB and lost our patents. And then we had to start all over again at the district court. And then the district court, after almost 3 years, said, well, the district court now is not the right venue. We had a trial date set, we had everything. They said, now this is a breach of contract dispute because the patent validity issue is not on the table anymore. You have to start over and go to state court. So we were in district court, the PTAB, the federal circuit. And by the way, and we had the other frustrating thing is we had attorney's fees in our contract. But what I also learned is basically, they muddied the water so much with this dispute that we weren't even sure we'd be able to get our attorney's fees back, which just was very frustrating for us, because they tried to appeal to the Supreme Court, and basically it asked for a rehearing, an en banc rehearing at the Federal Circuit. Then that got denied, and they got denied at the Supreme Court. So we had to go through all these different levels just to get the contract negotiate, the terms that we had in our contract that were negotiated, enforced. So $1 short and a day late, because we had already lost our patents, and we had basically effectively been bankrupted by this strategy, this legal strategy, which big companies use all the time against small companies. They just know how to pull the levers of the legal system to put more time on the clock for themselves. If you've got enough money, you are going to win against somebody else that has less money than you.
This isn't a strategy. This is just pure harassment, Patrick. This is just so infuriating, the way they're abusing the system against you. So I wanted to clarify a lot. I've heard a lot of questions and people asking, I mean, you have to go to the PTAB is kind of the thought, because if your patent is challenged, that's where you challenge a patent. But can you clarify, did MergeSource have an opportunity to challenge your patent in the regular court?
Yes, they did. We actually asked the court for a summary judgment, which would have been far faster and far less expensive for both sides, to go through a summary judgment on the validity and infringement stuff.
So you're not afraid to defend the merits of your patent?
No, we weren't afraid to defend the merits of our patent. We were afraid of defending the merits of our patents in the PTAB. We wanted to defend the merits of our patent in the district courts, where we thought it would be fair, and where we had our contractual, agreed upon venue, because there we could have fought with contingency attorneys, and it would have, basically when we entered the contract, that was our thinking. If we have to defend the validity of these patents, we can do it in the district court with contingency attorneys. We can afford to do that. We can't afford $500,000 at the PTAB.
So on that, I know we have another guest. Can I ask one more question before we go to that? Because the other thing that people suggest is, hey, inventors, that's why you should license, because this is too hard and it costs too much, and you need a partner in order to play the patent game. And can you just reiterate how that worked out for you?
For us? Yeah, well, I mean, this is such a frustrating thing. So, we were in the marketplace, we were selling a product. And what I also learned through this process is, there's no real way to get an infringer to even stop selling a product. These, injunctions to get them to stop selling are never granted anymore. So basically, if you've invented something and you're trying to sell it in the marketplace, good luck. You're going to have to go through court fight after court fight after court fight with any other person that's in the marketplace. And each one of those court fights is going to take years and require, hundreds of thousands, if not millions of dollars. So especially against big companies that have the resources who will fight.
You got to the point and you did license.
Yeah.
And that didn't, but then they broke the license and turned and attacked your patents anyway and drug you back into court. So you did what everyone says is to find a partner, not really a partner. You didn't choose them, but you had a license. And so that should have been the end of your problems. And that wasn't the case.
I mean, basically a contract, what I learned is the patent rights are so weak and so poorly protected now that even having a written contract with someone does not get you anything when it comes to licensing. The other side has so many tools at their disposal to weasel out of an agreement, to not honor it, and just bury you. I mean, if you've got a contract, it should be pretty cut and dry. Okay, you both agreed on this. This was an arm's length negotiation. If you didn't want to enter this contract, you shouldn't have signed the dotted line, right? Seems pretty obvious. But what I discovered 3 years and hundreds of thousands of dollars later is like, yeah, the court can be used to basically take something that seems so cut and dry, complicate it, and drive the expense of coming to a decision about what that contract means, that, you know, it's not worth anything. If the contract basically in contract takes that much effort, no. So.
We're actually losing you there, Patrick, but
One thing,
I can't believe everything you've gone through. And I think Randy has a comment.
right, I want to just for the viewers say one quick thing, because I missed this in the intro. I normally talk about it when I talk about the PTAB. So the PTAB, there's no jury. You don't have a lifetime appointed judge. You have very little due process. And what Patrick went to is an example of why you want a real court with a real jury, with real due process, with a real judge. They were using prior art, and for anybody watching who isn't an inventor, prior art is simply something that was done, either patented or not, but it was on the market, it was available, it was known before you invented your invention. So if it's been out there before, then you can't invent it. You can't get a patent on it because it's been done before. They were using a piece of prior art that came out, he said, 6 months after he had his on the market. So it's not prior art, and in a real court case, that would have been worked out, and experts would, I mean, it would have been obvious that this is not something that they can use in their fight, and he would have won the case. But of course, that's not how the PTAB works. It's very biased, and that's why we're fighting against it.
Yeah, and I would say that if the PTAB functioned well, they would have, in the first phase of this, recognized that this prior art was complete and utter garbage. But they didn't. They basically gave the benefit of the doubt to the challenger. Well, this will all be figured out, in the next phase. Well, the next phase is hugely expensive for the patent owner, and the only thing you get at the end of it, if you win, is what you started with. That's the very best that you can do in the PTAB. So by them, having that bar, by them not having a good enough filter on what they're instituting, they're really harming patent owners and inventors. Because right now, I have no trust in the patent system. I've basically let any other patents that I have, applications, fall to the wayside because it's not worth anything. Until the patent system is fixed, until this PTAB situation is resolved, it's not worth my time and energy and taking the risk and investing all of that effort in something that I can't protect. I've seen my company disintegrated because of this, because of how broken this system is. And it's not that I'm trying to, cram some bad patent down somebody's throat. These are people that came, if they didn't think our patents were valid, why did they come to us and ask to license them? I mean, it makes no sense. It makes absolutely no sense. And we, yeah.
Thank you, Patrick. I feel like your next book is going to be this thick, and it's going to be all the problems that you face. And the real irony is that patent examiners are an incredibly intelligent person. They do so much research. They spend a lot of time looking into your art, comparing it to other existing inventions. They really are very technical in their field. So when they issue a patent, they've done a lot of work to get to that point. You don't get a patent overnight. So it's a real shame. But thank you for sharing those, and stay with us, Patrick, because we'll be having a discussion a little bit later on. So our next inventor is Ron Williams, and he has innovation in his DNA. His father invented the popular Cajun injector that you might have seen at Walmart or Home Depot. Now, Ron had an aha moment when his eyewear retainers snagged while driving, and he almost ran someone over. He ended up, though, inventing and patenting a new type of eyewear retainer that is snag-proof, more adjustable, and more secure than the competition. Ron started producing Cablz, and it became a huge success. The invention attracted a lot of attention, and one of the awards Ron received was Best of Show at ICAST, the International Community of Allied Sports Fishing Trade. Let's have a look at a video.
Hey, my name is Ron Williams. I'm the inventor of Cablz eyewear. the first off-the-neck concept eyewear retainer, an award-winning retainer on the market today. And I want to show you a few of the options that we have on cablz.ca. We've got a yellow monofilament. It has the ball bearing in it, the award-winning ball bearing from ICAST 2009. We have the black cable. We have the clear cable, so you can actually see the cable inside. And we have a blue monofilament, just like the one you're seeing out here. But this is how the packages come. We had a lot of safety people and some linemen that really wanted the monofilament, and a lot of fishermen. And this is the old school original. And the best way to put your cables on your glasses is to take your everyday hand sanitizer, and you want to put just a little bit in the tip. All that does is lubricate it so it can go on your glasses. After a little while, it dries up. Whenever you want to take your glasses off, all you have to do is come over the top of your hat, just like that. You don't put it back on, you literally go under the brim. You never take your hat off, leave it on. I don't want them on my neck. So I made them where they'll stay off of your neck. You can adjust them in tightly, or you can loosen them out if you want, whichever one you prefer.
Well, things were going really well, and then he saw a copy of his invention at a trade show. Ron, thank you for joining us. What happened?
Yeah, we had launched in a soft launch into 2008, and then our hard launch 2009. We won that award in 2009, and then 6 months later, it was like July. 6 months later, we went to a show in Utah, outdoor retailer show, and actually, I was working the booth and walking around looking at different things and getting ideas from other people, and my son was there. He was about 10 years old. He came up and said, "Dad, somebody's got something like just like yours in the booth, and it's on a yellow head, and it's looks just like yours." So I went over there to check it out, and it was like a 40 by 40 booth. It was a real big company. That booth cost a lot of money, and I walked in there. I said, "Hey, who did this?" I picked up their knockoff off the mannequin and walked to the back, and I said, "Who did this?" And the guy who owned the company was sitting in the conference room with about 10 people, called me by name. I didn't even know him. And he made everybody leave. So we started talking, and he immediately said, "Hey, instead of suing me, how about we license?" And my first response was, I'm just not real big on thieves anyway. So I just said, "How can I trust you with a licensing agreement? I'd have to send an auditor to your building every day just to try to make sure that you're not cheating me." So that's how the knockoff started. That's when I found out about it. And we were able to get it in federal court locally. And here's what kind of blows me away. Took it to the federal judge here in Birmingham, Alabama, and she walked out. As soon as she walked out, the first thing she said before she even had a seat was, "We know the guy invented this stuff. He's a local guy. We've seen his product. My husband wears the product," and all that. She said, "So I really don't want to hear anything from the defense, because it's just no way y'all can tell me that y'all didn't knock it off. We've seen the knockoffs, and so there's nothing else can happen." So we were elated, and we're like, "Yay, we won it." And Mark Rasick, an attorney from Salt Lake City, came in and talked to her, approached the bench, and for about 3 minutes and walked away. She goes, "Well, you're right. I'm really not geared to work with patents and intellectual property and that kind of stuff." So she passed it on. So that's when we went to PTAB, and what bothered me the most at PTAB was everything, the facts and stuff they saw in front of them. For example, one of them was, these companies are saying that they don't have commercial success. There were 3 judges, and the lady judge there said that I'm looking at y'all's numbers, because they pulled everybody's numbers. And she said that these 2 other companies were actually that sell belts and shirts and hats and dog collars and sell all this other stuff, that our knockoff was 60% of, or at least 60% of their gross revenue. 6%. Those companies have been around for like 20 and 30 years, right? And so we thought we had it, one there as well. And we lost a patent, completely invalidated one of my 4 patents at that point. Wound up going back for one of my other patents, and they gave me the patent, but They wouldn't let it stand after they had gone through all the work, all the study. We'd gone through all the money. They've done all their research, and they actually were in the process of invalidating that one as we speak. But I don't think they will. But well, they probably will. I don't know. I really don't know. We had the biggest problem I'm having now is we have other people who are knocking us off, and they've actually contacted the same attorney that took us to court, and I have a letter written from the attorney. You know, if you even bother these people, not only will we invalidate your patent, but we're going to sue you for their loss of income off of my product. And it becomes a very threatening situation, and they use that because they know that the attorneys know that they're going to be that we're going to be invalidated, you know. And so it's really, you know, I've got several things I would really love to patent. I just don't even know where to start, honestly. I was talking to my partner a minute ago just to try to get some numbers, and I know that we spent at least $2 million just on legal fees, not including all the experts that we had to hire. So I can't even imagine that. But the biggest thing to me is if we would have won that federal case here in Birmingham, what are the damages? You know, I mean, they're in the, I was told not to use numbers, but they're in the hundreds of millions of dollars, because we're shipping stuff to Australia, we're shipping stuff all over the world, and basically what I have to go on is my name. You know, I'm glad I had that trademarked, and it's standing strong, and people are asking for it by name. So now I have to swap the attorney's fees over to marketing and to build it. Good news is we're doing good, but it's just amazing the damage that was caused, and emotionally, financially, family, everything. You know, it's just devastating. And I have been talking to Josh for a long time, and I'm so happy that he took charge and ran with this with his friends and all you guys that are out there trying to help. We need it. We need it bad, you know. So, and that's really it in a nutshell for me. They just we just have to turn to marketing, and it's sad. Again, I've got so many other ideas that will patent that I know that will change the marketplace, just like Cablz did. It's a very simple idea, but you see them everywhere, you know, and it was completely against how the current market was flowing. You know, everybody wearing the sock retainers and nasty ones and all that kind of stuff, that you lose your glasses. And it was just, it's kind of a bittersweet when I see people walking around with my concept on that's not mine. You know, like, well, at least I changed that market, but I sure would like to have been paid for it.
You lost certainly a few $1 million fighting them. And basically the infringers are out there producing it like you never did anything. It's like it's their idea. And there are other infringers that are also producing and going to be producing. And all you're left with is a small piece of the market that you're marketing to. And I'm glad you're able to have some success with it. But it is so unfair that these guys could just take it and use the system that was supposed to protect you. And again, we get back to, if it had just been without the PTAB, if it had just been a real court with a real jury, with a real judge and real due process, you would have won this thing, and it would be a fair system. Absolutely.
I think it has to be a jury trial. It really needs to be. Kind of like the guy that did the windshield wipers, you know. I mean, I think it really needs to go to jury. I mean, it's the guy that is self-funded USPTO, PTAB, so they're incentivized to keep us all in there as much as they can and run the money up. So I'm looking for a break. I could use a break, you know.
Thank you, Ron.
I
think Randy wants to add something.
Just, you know, as you know, we're fighting for you, and we're fighting for every inventor and for every American who cares about this country and what it's founded on and what made us the most innovative country in the world and so different than the rest of the world. We are fighting for that every day, and with your help, this is a grassroots movement. We need everybody as part of it.
Absolutely. I'm all in, as good as I can be in. Do the best we can. I really appreciate all of you guys' help.
Thank you, Ron. there are some people out there who question our motives and question what we at US Inventor are actually doing. They question if we're here as lobbyists, if we're trying to finance and create jobs for ourselves. They question why we stand up and push hard for change. They question why are we so outraged. We at US Inventor and our volunteers and our donors are working tirelessly behind the scenes. All the while, we all have businesses to run too. We have inventions to bring to the world and problems that we want to solve. And we could decide to turn a blind eye to what's happening out there, but we choose not to. Now, as inventors, and I'll talk briefly here about what happened to myself and my business partner, Fred, we saw our bank account being depleted to the point of almost going out of business because of costly motion practices employed by serial infringers lawyers. At that time, we didn't know of anyone who could help us. We felt lonely. We were almost broke, and we felt that the legal system had somehow let us down and abandoned our small American business. Now, this might sound familiar to many of you listening today. We all as inventors didn't want what happened to us to be thrust upon any other inventor. And that's why so many inventors, entrepreneurs, and small business owners join in US Inventors' efforts to protect the rights of inventors. When I hear stories from inventors like David and Stephen and Ron, or the story of Darcy Bisker, the inventor of the decorative photographic tile, whose business partner and best friend died of a heart attack the day after their appeal, or the story of Randy Cooper, a kind, thoughtful, and selfless man who embodied the spirit of the American inventor. He invented the noodle head sprinkler. He passed away because of the stress of the battle against infringers just became too much. Or the story of Mark Kilborn, who invented a remote control way to open the deadbolt on your door, who didn't make it to our show because the stress of dealing with having to go through PTAB to defend a patent that was awarded to him caused him to suffer from an aneurysm. Now, these hardships and these losses are incalculable costs, and they're not isolated examples. There are so many more out there. Let's not forget the hardship that many inventors have faced when their businesses were crushed by the corporations who chose to use the legal system as a tool to drain inventors' last cents, where infringers choose legal action over paying licensing fees. Inventors have lost their homes. Their health is suffering, and so are their families. And yet, some people question why we are here and what we're trying to do. Well, let's tell you why we're here. We are here to help. We're not here to shout or scream, but of course, the extremes we've all faced given us reason to do so. This is a struggle for survival, a battle to save the American dream. We are passionate about what we do. Now, ladies and gentlemen watching this show, you'll be impressed with what US Inventor has accomplished. We are making a difference, and we want to share some of that great work that we've done with you. And I'm going to pass it to Randy because he's been here from the beginning with Paul Morinville and then Josh. Tell us about US Inventor accomplishments.
If we go back to how US Inventor actually was formed. So in December of 2013, a terrible bill called the Innovation Act, and many of you haven't heard of it because it didn't get passed, and it was because of what we did. We were instrumental in stopping it. But only 2 years after the American Invents Act, suddenly they have another bill. It goes through Congress. It wins in a landslide. It was like, 325 to 71, something like that, 91. And, they weren't able to pass anything else in Congress at the time, but man, they all got together to destroy our rights. And one of the things this bill would have done is it would have put in what it's called loser pays. That's where if you sue a huge corporation for patent infringement and you don't win, and maybe it's just because they have way better attorneys than you, you don't win, suddenly you could be responsible for their legal costs, even if it's not a frivolous case. So you're talking about perhaps having to give them $5 million. In fact, the way they had it written, if you had an investor who had an interest in your patent, they could go after and you didn't have the $5 million in the bank, they could go after the investor and take his home, take his personal property. This is horrendous for American innovation. But no one was aware of what the big lobbyists were doing behind the scenes and lobbying this false narrative about, oh, patent you know, people about abusive patent litigation, all these good, decent companies being harmed by all these terrible people trying to sue them for patent infringement. And so I found another inventor like myself. I mean, look, it passed December 2013. There we were, January 2014. I'm on the phone calling inventors around the country saying, hey, we got to fight this thing. I found another inventor like me doing the same thing, Paul Morinville in Indiana. Got on the phone with Paul, and he said, hey, we got to go to DC and stop this thing. I said, you can do that? And so we went to the Senate. We went door to door. We went to 70 offices, and the staff members in these offices, one for one, said, wow, I didn't know there was another side to this issue. We just were told it's a good bill and we should get behind it. I'm convinced that if we hadn't been there in early January fighting this, informing the people in the Senate of the truth, that bill would have passed. And so we slowed it down. It didn't get anywhere, but the next Congress came back. By then there were some allies, big fight. And in the end, it never got to the floor, which, by the way, I've been told by people way smarter than me, who've been around way longer, that no bill that passed that kind of way with those kind of numbers in the House has ever not passed the second time when it came through the House. Never happened before in the history of America. This one didn't even get to the floor. And not only did it not pass, it didn't get to the floor. So big victory for the good guys. And that's how US Inventor began. And actually we've had verification since then. I won't tell you exactly, but we know that our efforts were instrumental, were a key part of winning that fight. So that's how we began. And since then we've had other battles. In fact, just this year, in fact, I'll even let Josh chime in on what we've done recently.
Yeah, thanks, Randy and Natasha. Yeah, I appreciate the opportunity to address, you know, is US Inventor effective, and are methods working, and do we know how to advance the cause? And a lot of the comments are about that. What do we do? How do we make things better? And we have made things better. Things are improving, but as these stories here say, we're still not nearly there yet. And one opportunity we found, I mean, when I went to, you know, when I encountered the broken patent system and I came to Washington, I found Randy and Paul, and they were there for me, and they absolutely turned my case around when my lawyers couldn't. And when we went and exposed the abuse that was going on at the patent office, and you know, through some tactics that some consider controversial, hey, I was desperate. I was losing everything I worked for. And when we came out and we rallied and we drew attention to what was going on, things changed. And in my case, things changed. We had complete change in management of the patent office as a result of our work. It was run by a former head of patents for Google, and now it's run by a pro inventor director. And he's making changes, and throughout this year, there's been a process of making the playing field fair at the PTAB, and we've learned how the system works. We understand the difference in statutes passed by Congress and regulations passed by the agency, and we're in the middle of these things. And when they try to do it, when they try to undermine the due process, or they try to take shortcuts and they make up their own laws, we're catching them, and we're there and we're exposing it. And so the effort that's going underway right now says, addresses the law as it was passed in 2011, which said the patent office, the head of the patent office, should pass rules and regulations to prevent this abuse. Well, guess what? They didn't do it. And for 8 years, the PTAB has been basically unregulated and a complete violation of the law. So now we're in a lawsuit over that. You know, we flipped the tables on big tech when they went to the courts and complained about some results they didn't like. We jumped into that case and we said, wait a minute, it's the other way around. They're not following the law and the way they carry out the PTAB. And so now we're in a process both in the agency and in the courts, and there's an effort as well in Congress. So we're figuring it out, and it's very fresh. We bring a whole new perspective that hasn't been thought about in a long time in Congress and in patent office and the courts. patents have had nothing to do with innovation. It's all been about how do we divide up the spoils of these inventions that already exist. And so for the first time in a long time, we're bringing that perspective of patents aren't about what we've already come up with. Patents are the incentive to solve the problems of the future, and these policies impact that. We're making a big difference.
Well, thank you, Josh. And I wanted to take some questions, but we're at the end today. So I'm going to ask anyone, if you have questions, please send them to us and we will put them in front of the right people and answer them. In fact, we'll even put them on the website so that we can answer questions for you. So at this point, I'd like to remind everyone to check out US Inventor. Check out all the tools we have there. If you go at usinventor.org elections, you can access a tool that will help you engage directly with your representatives. And we'll put videos there and summary points. So check it out. So it remains for me to thank David, Patrick, Ron, Josh, and Randy. And to everybody who signed in, please keep the good work up. Over to you, Randy.
Thank you, Natasha. And thank you, everybody, all the panelists who attended, and Josh. So this is a grassroots movement. And a movement like this depends on a lot of people being behind it. What matters to politicians is their voters, okay? Josh and I can go to DC and talk to a lot of people, and it can make sense and they can get a little bit behind it. But if their voters don't indicate it's of interest to them, it matters to them, it's hard to really push it through. And what we need for all of you listening, not just inventors, but we need small business owners, people who just care about America and the American dream and what makes America so different than the rest of the world. This is a key part of this country. And we need all of you to go to our website. The way you join US Inventor is you simply sign our Inventor Rights Resolution at usinventor.org. You sign it, very simple. If you look at it, you'll agree with what's on it. It's very simple. And what that allows us to do is, one, when we meet with congressmen, we can say, look at all these people in your district who care about this. But also, we might get a meeting set up in your district, perhaps locally, and invite you and all the other people from your district who signed the resolution. The point is, we make this something that they can't ignore because their voters care about it, and their voters should care about it, which part of what we need to do as well is get the word out, because I found that virtually everybody that I talked to about this becomes an ally, and typically they knew nothing about it. They assume patent, if you get a patent, you got something, and you can do something with it, and gosh, if I just get a patent, I'll get rich. Well, they need to know the truth, and we need everybody to be part of this effort, because we have moved the needle on this. We're moving things the right direction, but there's a long way to go. So I would say to everybody listening, go to our website, usinventor.org, sign the Inventor Rights Resolution, and be a part of this really critical movement for the future of America. Thank you.